The question I addressed in this report is whether it would be advisable from a public policy perspective, and specifically from California's interests in maintaining a competitive innovation economy. Would it be a good idea for California to adopt some or all elements of the Digital Markets Act that has been enacted in the European Union and has been implemented since approximately May of 2023? And my conclusion in the report, as you know, is very simple, that it would be inadvisable. It would likely be against the best interests of California's innovation economy and ultimately the California consumer to adopt the approach reflected in the Digital Markets Act. And what I'm going to endeavor to do in the next 10 minutes is to condense an almost 60-page report into 5 big reasons why I reach that conclusion. The first reason is really a big picture data point. The California innovation ecosystem is universally recognized as the highest performing innovation ecosystem in the world. There is no peer to it. And therefore, following the principle that if something is not broken, we should be really careful about changing any part of the existing institutional infrastructure, we might want to act with extra caution. And related to that, part of this first reason is that if we look at the largest, most successful, as measured by revenues, technology firms in the world, most of them are located in the United States. The largest portion of the US-based firms are based in California. All of the remaining, if you take the top 15 firms every year since 2018 by revenue, most of them are US firms. The largest portion are California-based. The remainder are in Asia. You will not find one firm in the European Union that falls into that category. Just to give you some context, the current federal antitrust case law and the approach reflected in that, which I'll be describing to you, has been in place for almost half a century. The reason I want to emphasize that point is while there are lots of other factors that explain California's success, the antitrust legal infrastructure that I'm going to describe to you has been in place for almost half a century, and the innovation economy in California has exploded and outperformed every other innovation economy during that time. By contrast, Europe, which of course has only recently operated under the DMA, but the DMA, as I'll explain, reflects certain elements of European competition law that have been in place throughout this period. Its innovation economy during this time has declined. Outside of pharmaceuticals and certain portions of the wireless sector, the European Union is a minor player in the global innovation economy. It therefore would seem that we should act with some caution in importing elements of the regulatory structure that they have been using during that time. The second point I would like to make is that California-based tech firms already operate today under multiple layers of antitrust scrutiny. And from a certain perspective, it could arguably be said an even stricter level of enforcement than exists in the European Union. Let me explain to you why I make that point. The California innovation economy is, of course, subject to the federal antitrust laws. Unlike in Europe, though, it is enforced not just by the federal enforcers, It's enforced by 51 state attorneys general. On top of that, only the US has an active class action bar that also has private rights of action under those antitrust laws, and they use them actively. There is no comparable equivalent in the European Union. That's not all. California firms are subject to the Cartwright Act. And while California courts' case law generally mimics the case law of the federal courts under the Sherman Act in order to provide relatively uniform treatment, the California courts, the California Supreme Court, has been clear that the Cartwright Act does afford California state courts latitude to find liability where a practice violates the spirit of the antitrust laws, even though it might not violate the letter. And just to finish up the point, the Federal Trade Commission, under Section 5 of the FTC Act, has similar such latitude. I want to emphasize this point because it's sometimes argued today that the existing antitrust structure in the US is lax, especially as compared to Europe. For the reasons I've mentioned, I don't think that is at all clearly the case. In fact, it could be argued that the level of enforcement, when you take into account how many actors can bring causes of action, may be even stricter. The third point I would like to make is to draw an important distinction between the antitrust tradition in the US, which is a common law, litigation-based tradition, founded on the application of the rule of reason. The DMA reflects a different approach. It's a regulatory approach. It sets rigid, per se, illegal categories of activity. It operates ex ante. The rule of reason outside the clearest cases of collusion, which I don't believe is your focus, has been a feature of US antitrust law well before the so-called Chicago Revolution starting in the 80s. In fact, one of the originators, the pioneers of the rule of reason, is Justice Brandeis. Many who argue today for a Brandeisian approach to antitrust argue that we should revert to greater use of per se rules. But Justice Brandeis, in the famous case of US v. Chicago Board of Trade in 1917, argued just the opposite. He argued for the rule of reason. Why did he argue for the rule of reason? Because he argued for the rule of reason is necessary to give courts a full picture of the pro-competitive and the anti-competitive benefits of a particular practice. And one thing I would like to emphasize is that in the ensuing decades since that Chicago Board of Trade decision, the Supreme Court has made clear, especially in a case known as California Dental Association, that the rule of reason comes in many varieties, and courts should feel free to apply it more strictly, less strictly, greater or lesser fact-finding, depending on the complexity of the case. The rule of reason is far better founded in the economic literature than the per se rule, and that's because the economic literature almost universally recognizes that outside the clearest cases of collusion, which are always anti-competitive, that antitrust is hard, that many of the practices challenged in antitrust cases have good and bad effects on competition. This more careful approach, this litigation-focused approach, has allowed for a balance that on the one hand gives enforcers tools to protect consumers when anti-competitive practices are being used. But at the same time, it provides guardrails. It holds back the prosecutor's hand so that a chilling effect is not caused that can discourage innovation. The last point I wanted to bring up, I won't get to 5, but I kind of merged it into 3. So I'll make this my last one. The last point I wanted to bring to your attention is that one of the arguments that are sometimes made for the DMA is that it will lower costs because instead of having litigations that go on for years, which can be the case, instead we have clean regulations that are easy to administer. If you've read the DMA, which is a complex statute, you might be skeptical of that, and your skepticism would be confirmed in the short period in which it has already been in operation. It has triggered disputes with regulators. It has triggered litigation over the interpretation of regulations. It is entirely possible that adoption of the DMA is more expensive than litigation-focused enforcement, since litigation occurs periodically, whereas the DMA would require California to set up almost an entire new regulatory entity to interpret, administer, and enforce the regulations. Thank you, and thank you for the extra few minutes to finish it up.